Good morning.
Morning, Alejandro. We won't need you this morning. We have one case and it's all attorneys.
Okay.
So
Okay. Bye-bye.
enjoy your day.
Likewise. Thank you.
Bye-bye.
All right, good morning, everyone.
Morning.
Call the items that are on my voluminous docket for this morning, Thursday, 17/2022, starting with the one and only case I have this morning. Vargas, Figueroa. All right, so we have a motion to, what do we have, gentlemen, this morning?
Good morning, Judge.
Morning.
Terry Canales for Mr. Hector Vargas, the plaintiff. Judge, there's a couple of things pending. There's a motion to compel for Mr. Vargas, my client, the plaintiff. I believe Mr. Figueroa on behalf of Mr. Rodriguez on behalf of Mr. Figueroa has filed a motion to compel. There's a motion to strike an affidavit, and there's a motion for contempt and sanctions. And so I think mine is the oldest in time, but we'll take them up as the court decides.
That's right, Your Honor.
Good morning, Your Honor. This is David Bryant from Magellan. My client is not a party to any of those motions today, but I'm listening in, although I may have to leave a little bit for another commitment.
Okay, thank you, sir. All right, well, gentlemen, I hate to give you some bad news, but my coordinator who's in charge of preparing my files is on way to Houston medical treatment, and unfortunately she did not.
I think from Mr. Vargas' position, Judge, if I may address the court, I think we'll probably make it a little easier for you this morning with respect to our motion.
I always want to hear easy, so go ahead.
Well, Judge, we'll start with the good. Is that since the filing of our motion to compel, Mr. Rodriguez and his client have produced and answered some of the stuff that we're working towards, and I want to thank Mr. Rodriguez and his client. We've worked through a lot of it, Judge. As we told the court last time, there was approximately 8,000 documents dumped on us, and the court referred to it as the Ford tactic. And so we've been sorting through that, but that's the good. The bad part is about 3 weeks ago, after representing to this court and to me and to my office on several occasions, Mr. Rodriguez said that everything that was relevant had been turned over. And this court actually made a comment saying that if it hadn't been turned over as pursuant to the discovery, it wasn't going to be admissible. 3 weeks ago, they dumped another 1,000 documents on me, Judge. And so that's the bad. And so they're not specifically responsive to any requests, just here, go look for it. And so at this point, I said easy for the court is that we want to temporarily withdraw our motion to compel so that we have the opportunity to review the new 1,000 documents and determine whether we need to amend and or fix the motion so that it's accurate. We're not wasting the court's time. So at this time, we would make an oral motion to temporarily withdraw subject to a refiling that is more consistent with the facts as the discovery has unfolded.
Okay, Mr. Rodriguez.
Your Honor, I mean, if I need to respond to that, I will.
Well, no, you don't, but because the court obviously would always engender us to try to avoid hearings to compel and all that if possible. And if Mr. Canales is representative, he's next more opportunity to make sure that it's not wasting my time. That's appropriate, and that certainly is commendable, and I appreciate it. So we'll reset that motion to compel. Is there anything else pending?
Yes, my motions, but as far as that motion goes, I respectfully request that whatever problems he has regarding those responses, that he gives me an opportunity to fix those problems just like the rules require. So I'm telling the court we're ready, willing, and able, and we have been ready, willing, and able. And we did have a conference, a Zoom conference, not with Mr. Canales, but with his associate, in which we took care of and we discussed the entire set. And we left that meeting with, I've got everything. I'm okay. And now we're back at it again. So I'm just saying, if there's an issue with what we produced, give me an opportunity to fix it. I'm ready to proceed on my motions. And I would like to start with our motion for contempt, Your Honor.
Okay.
The motion for contempt, this would actually be a second motion for contempt, Your Honor. Unfortunately, if the court remembers, the first one I screwed up and called it a motion for sanctions. But this is really a motion for contempt. The first one was in regards to Mr. Vargas's total disregard of the court's order when he took out that $75,000 from the bank account that you had ordered him not to do. And we had that hearing.
That happened 2 years ago, 3 years ago?
Yes. And the reason I'm bringing it up is because in that hearing, which was September 9th, Your Honor, that hearing was a plaintiff's motion to enforce temporary. May I share my screen?
Sure.
Hold on. Let me fix the settings. Okay.
Oh, I'm gonna get my coffee. Hold on.
Yes, Your Honor.
All right.
On September 9th, Your Honor, we had several hearings. It was a long day, but we heard several motions. One was a plaintiff's motion to enforce temporary orders. Our motion, defendant's motion to compel plaintiff's document production to defendant's discovery request, and defendant's second motion for sanctions. The motion for sanctions dealt with, again, Mr. Vargas's taking the money from the bank account when you had told him not to. And what we did here, we started off with our motion to compel. It was my motion to compel, and you say, let's start with that one, with the motion to compel. And I say, and apparently, and I just want to bring this up to the court, apparently we had already had another motion to compel. So that one was a second motion to compel. And we go, and what we were asking for were documents relating to Mr. Vargas's tax returns. And I know we've had a big hearing about that, and the fact that he didn't file personal income tax, even though he led us to believe he did. What the court said, well, in this regard, Mr. Vargas needs to produce his partnership interest and how he's reporting his interest into ABC. And that will be ordered to the extent for him to produce those income tax records that will relate how he reports his interest in the entity. We didn't get that. More importantly, though, Your Honor, we were.
This is a motion to compel or what?
Well, this is a motion.
You're complaining that you didn't get the information back then. I thought we were going to go to the relevant parts that has related to the discussion of the 75,000 he withdrew.
No, what I was saying there was that was the basis of our motion for sanctions, which should have been titled a motion for contempt. Mr. Vargas admitted that he took the money, and instead of me titling it a motion for contempt, it was titled a motion for sanctions. So all I was trying to say, and I don't want to get into the weeds, is this is really a second motion for contempt. And what he did was fail to produce those documents. And additionally, in that motion to compel, we were seeking documents that Mr. Vargas had produced in the Five Oaks lawsuit that Mr. Bryant was prosecuting in Houston. And the reason, and we got into a discussion as to why we needed those documents, and the reason, very quickly, we needed those documents because we needed to see if Mr. Vargas did the same thing as claiming he owned assets, that the same type of claims he made in the Magellan lawsuit that the court is very familiar with, and he was dishonest in that court that caused the big problem with Magellan being in this case. And what I was trying to do is get the court to order him to produce the documents in the Five Oaks lawsuit that Mr. Greg Trevino was defending Mr. Vargas in. And then Mr. Hinojosa says, well, I don't have those documents. They're not in my control. And then I said, because Mr. Hinojosa says, I don't represent him in the Five Oaks lawsuit. And I said, well, that doesn't matter. That's not a good objection. I don't have anything. Mr. Hinojosa says that he didn't have anything, but what the court said was right here on page 14. Well, what he needs to do is release Mr. Trevino to release that information to me. All he has to do is send a letter, whatever you gave those people in the Five Oaks lawsuit, those documents that are mine, give them to those guys. That's what you said, and it was agreed to by Mr. Hinojosa. Your Honor, I'm representing to you. I talked to Mr. Greg Trevino, and nobody ever asked him for those documents. So I would, and I'm telling you, we didn't get them. So I would like, and I'm asking the court to make a finding of contempt for Mr. Vargas not producing those documents.
Okay. Is that all your motions this morning, Mr. Rodriguez, or you have another one?
I've got another one, and it's very telling, and it's bigger than this one, Your Honor, and it's by you.
May I briefly respond, Judge?
Yes.
Okay, so Judge, obviously the court is aware that I did not have the luxury of being at those hearings, and so I was therefore unaware. I do take discovery requests extremely serious. So I went back after Mr. Rodriguez sent me a letter saying, and receiving the motion to compel. We didn't receive a motion to conference before the motion to compel, but nevertheless, we received the motion to compel. Now, immediately, we called the client in and he responded to those questions that Mr. Rodriguez was asking for. Now, I would tell you this, Judge, and we would ask the same professional courtesy of Mr. Rodriguez is, give us the opportunity. I was not aware of the 2019 hearing. We've scoured our emails from Mr. Rodriguez since we began representation. We cannot find any correspondence from Mr. Rodriguez since we began this representation where he seeks this information from us. And so we're doing our best, Judge, to play catch up between the 9,000 documents that have been dumped on us and then coming back. And so at this point, we have now requested previously, I'm not sure of the date, but we have requested from the clerks this court all live pleadings, all orders, so that we can comply with whatever's going on, because obviously there was something pending from 2019. So we would ask this court respectfully to deny their motion and allow us to conference and settle whatever it is, Judge. We've got no problem answering it. Whatever it is he needs, if we've got it, we're going to turn it over. We would just appreciate and the professional courtesy to play up. We've been playing catch up since we got here, Judge. And I think that this pulling something from 2019 is difficult.
I understand, Mr. Canales, and you're right, you're playing catch up. But sooner or later in this lawsuit, you're gonna have to stop using that. You have to get on it, and if it doesn't exist, you don't tell them it doesn't exist. But here's the other thing, Mr. Rodriguez. I guess finally here we went through a period of both of you. We went through a period where this was after the withdrawal of Mr. Hinojosa, but due to the fact that Mr. Bryant took over those claims that he was prosecuting, that kind of set this case into a law. I really wanted to have this case prepared to try while I'm on the bench, and then I would be the most certain thing would be for this year, because this election, I don't know, one never knows. I might not be around next year, so I'd like to try it this year before before we get into another year, and that's the endeavor. I don't know. I haven't looked at what. In fact, this discussion this morning is triggering my memory. I had intended to look at the rules to see if there is still a provision that allows this court to appoint a master for the limited purposes of getting this discovery done between both of you. Because we're going at this piecemeal. We're going to arrive to the trial date with still complaints that their documents have not been produced, things have not been answered, la. So if I have authority to do that, the court is inclined to seek somebody to monitor your discovery and make sure that both of you are cooperating and exchanging discovery timely, or you're extending professional courtesy given the deadline of this trial. I don't know. Do we have a trial date? We do, right?
Yes,
Your
sir.
birthday, Your Honor. But I'd like to be heard, Your Honor. It's your birthday, Your Honor.
Huh?
I think you said it's on your birthday.
Oh, yeah, my birthday's coming up, Mr. Rodriguez, and I really do like to have cake on my birthday. Even if it comes in form of litigation cake. So in other words, I want to keep the trial date. So can
Judge,
can either one of you or both of you answer that question? Am I authorized to do that still under the rules?
I believe you are, Judge, and we would be in agreement with that. In fact, we believe it would help streamline the process and difficulties.
I'm thinking really seriously that it would, because look, it cuts down the time that you get a hearing with me. This person will be available. You guys get on a dispute, you get on the phone with them, and he'll do whatever he has to do. I can take suggestions from both of you as to who I should appoint. So that way that nobody says, well, no, that person has it against me, or well. So I will invite both of you to have some input in that decision by providing me names of potential people that you think would be good at serving as masters in this case.
I think additionally, it'll help us streamline the trial, Judge. I agree with the court, and we will make our recommendations for the court.
Mr. Rodriguez?
Your Honor, if you have somebody in mind, just say it, and
I do not. I'm going to ferret through my mind as to who I need to do this. It would be as fair as objective as it can, and rule this matters according to the rules of civil procedure or any other matters, So I have to give that careful thought, so make sure that this does not turn into a partisan situation or allegations here. Okay.
not a problem, Your Honor. Whatever the court desires, but I would like to finish and make sure that the court is not tricked here into what's going on here, because this is not a motion to compel. I do have a motion to compel, and
it's a motion for contempt.
That's right, and I do have a motion to compel, but Mr. Canales kind of made this into a motion to compel. It's not a motion to compel. I do have a motion to compel, and I'll be glad to talk to him about the motion to compel.
Okay, well, that would be great. So addressing your motion for contempt, because he has not done that. I don't know if he has, and neither do you, unless you can represent to Mr. Canales and to myself that those 1,000 documents that you delivered to him as a press for his as per his representation, does not contain in any way anything that is relevant to you regarding this. I've contacted Mr. Trevino or advising Mr. Trevino. And further, I don't know, as Mr. Canales stated, whether he has anything or whether Mr. Trevino can prove that he has done it. I don't know. I don't know what's going on in terms of that. But let me ask you something, Mr. Rodriguez.
Yes, sir.
If in fact, Mr. Vargas has made statements in that lawsuit that you refer to that you need in order to prove, I guess, a course of conduct, that he has done that in this other in the other instance, as like he did in this one. He structured his business the same way as he did in this one. You're basically giving evidence of course of conduct. So in that regard, if his pleadings in that case allege and take a position that is contrary to or is similar to the same setup that you have in this case, why can't that be a judicial admission? Mr. Rodriguez.
Why can't it be a judicial?
Why can it not be a judicial admission?
Okay. It can't, because what he did in the Magellan case, he swore that he owned these assets. And so we don't want it to be a judicial admission. Mr. Bryant wants it to be a judicial admission. I don't, because he can't give away my guy's 50%. So
No, not in this case.
Okay.
I mean, you earlier told me that in the case of Mr. Carino representative that you wanted that information so that you would be able to prove that he had similarly structured a deal in that case, similar to this, where he was alleging that he owned certain percentage of certain businesses on his own, right? So what I'm asking, why are not those pleadings where he makes those allegations judicial admissions?
Well, I'm not sure I'm understanding the question, but the point is, I wanted to see them. That's the point. And they're his.
No, I understand what you want, but I want you to understand that point so you can answer it for me. And if you tell me it can't be because of this reason, Judge, then I'll move on. But I need to have an answer to that. So I need to be clear with you so you understand my point. Earlier, you told me that you wanted documents from Greg Trevino, who represented him in the Magellan or whatever other lawsuit he had, right?
Yes, he represented him.
And then you told me the reason for that is because you wanted to prove that he had acted in his business dealings the same as if he was in this case. That's what you told me, right?
I think I said I wanted to see if he did, not to prove. But
Okay.
Okay.
Is there anything that you cannot glean from the pleadings that were filed in that case that would make you confirm that in fact he did, and then pursuant to those judicial admissions he made in that case, or whatever you want to call it evidentiary wise? Maybe it's not a judicial admission, but I think that that's the way that I see it, because he went to a court of law and judicially admitted in his pleadings that he did this and he did that. So you can take copies of the pleadings, certify them, say this need to come in as judicial admissions.
Good point, Your Honor. But
but hold on, let me finish my point so you'll understand it clearly and so you can answer it. So now what I'm asking, so if you look at those pleadings will guide you to his assertions in what he was thinking about in that matter that may give you a more focused perspective on what you want based on what he alleged to further prove that he acted consistent in claiming ownership of things that he never owned. I don't know, am I clear now?
you are clear, and I understand the question. The problem is that you don't file discovery anymore. So if it was the old times when I was and you and I were younger attorneys and all discovery was filed, I could
Okay.
go get them.
I agree with that.
Okay.
But let's just stay with the pleadings.
Okay.
Do you have a copy of those pleadings? They're public information.
They are.
Do you have a copy of them?
I do not recall. I've got some orders regarding that. I do not know if I have the pleadings.
Well, can you do me a favor? Can you see if you can review those pleadings? And if in fact he made assertions that are consistent with what you believe he did, then we'll move on the discovery.
Well, wouldn't it just be just as easy, Your Honor, to do what you ordered, to call Mr. Trevino and say, if you produced it to Mr. Bryant in that case, give it to Mr. Rodriguez. That's it. It's that simple. And
we've agreed to do that, Judge. We've told you that on the record. I wasn't aware that this was happening, and so if that's what Mr.
Well, here's
Rodriguez
the other angle.
will do it.
If Mr. Bryant has those documents, he is a party to this as a counsel, and is also representative of any entity that may be affected by any position that Mr. Vargas took in that lawsuit. Why can't Mr. Bryant be asked to produce those documents?
I don't know if he can, and I don't speak for Mr. Bryant, but I don't think Five Oaks is a party to this lawsuit. So the fact that Mr. Bryant represented him over there.
I know that, but we need Mr. Bryant here to tell me, does he have documents that were produced in that lawsuit? If he says yes, then we have another avenue to get him, right?
Absolutely. If he
Okay.
received
All
them.
right. So why don't we, first of all, why don't you do me a favor, Mr. Rodriguez, if you could, because my curiosity is now piqued. So why can't it, I don't think it'll take a great effort for you to get me a copy of the pleadings that he filed in those Oak lawsuit, so that we can see what it was his legal position at the time. Secondly, if maybe convene another hearing and get Mr. Bryant involved and so hopefully he will make a representation to the court that he does have documents that were produced in that lawsuit. Thirdly, to figure out a way where Mr. Bryant has to give them to us, to you guys. Can't that work too?
It may be.
Well, and so at the same time, we'll allow Mr. Canales to keep on plugging and finding his, see if he has them. So you'll have two possible sources of getting your documents.
Yeah.
Wouldn't that work, Mr. Rodriguez?
It would work, Your Honor.
Okay.
This is David Bryant, Your Honor. Could I pipe in here and just help you a little bit?
You can pipe in anytime, Mr. Bryant.
Your Honor, the only, to my knowledge, and I did not represent Five Oaks, but I've read the pleadings in the Houston case brought by Five Oaks Commodities. Mr. Vargas filed no pleadings in that case. Rather, he defaulted, and a judgment was taken against him by default. However, I know he did respond to some post-judgment discovery requests that the lawyer for Five Oaks served on Mr. Vargas's lawyer, Mr. Trevino. Mr. Trevino provided certain documents to the lawyer who at that time represented Five Oaks. The lawyer for Five Oaks has provided some of those, I think all, but at least some of those documents to me. I've never been asked to give them to anybody who's a party here, but I'd be happy to do so.
Thank you, Mr. Bryant. Thank you. There you go, Mr. Rodriguez and Mr. Canales. All right.
Thank you, Judge.
Okay. Now here's the deal with your motion for contempt.
Your Honor, I'm not finished.
I'm sorry. Go ahead.
It's really important because it deals with what you ordered.
Okay.
So then we started talking about the relationships between Mr. Vargas and these entities, Mega and Lingo. And we start talking about what's owed and what
yeah, I remember that the loan company, they loaned him the money in Mexico and
Yes.
different things and whatever. Yeah, I remember all that discussion.
Okay. And what we were trying to do was get down to the brass tacks.
Okay,
What was loaned, what was paid already, and all of that information. And it kept going back and forth. And it started off with me asking him about what he alleges that he put into this entity, because the pleadings, and Mr. Canales is still on this path here, says that he put in $7 or $8 or $9 million. And we were trying to get that information. And so I started to ask him about this. How much are you claiming you paid for the construction of the terminal? And he says, with or without interest. And I said, let's start off without interest. And he admits $3,800,000 or $3,900,000. And we're still getting discovery asking us to say it's not 7 or 8, but that's a different point. We continue to discuss this, and then because he had already in a deposition said it was $7.7 million. And then he says, yes, of course it is. So is it 7.7 or 3.8? And we go round and round about that. And then we talk about Mega and Lingo here. And then the court comes in because Mr. Vargas went from 7 or 8 to 4 to 5. And here's what's important. And this is why I'm saying the court needs to find him in contempt. The court takes over. You take over, Judge, because he flounders and you say, no, no, no.
it was very difficult. The testimony was very tortured. I remember that.
Okay. Okay, we go back and forth, and he contradicted himself over and over again about how much he paid.
I
and how much
remember.
was owed.
I remember.
Okay. Okay, and getting to the point, and I can tell that the judge want me to move on here. Well, I also wanted to bring up the fact that during that hearing, you, Judge, you saw a gentleman by the name of Enrique giving signals to Mr. Vargas while he's on the stand, and you called him out about it. That's
I
the
did.
gentleman.
I recall that too.
That's the gentleman that I would like to depose, and they are not cooperating by asking him to sit for a deposition, because frankly, Your Honor, he has information that I think can clarify all this information that Mr. Vargas goes back and forth on. So I would repeat my request for you to tell them to produce that gentleman for a deposition, or direct them to ask their client to ask him to do that. But
Well, I can only order it if they have control of it. If they don't have any control of it, I won't order it. Do you have control of it, Mr. Canales?
Judge, we've actually had this discussion with the court. The court has already gone over this because Mr. Rodriguez has a great memory, except when it comes to what we already went over. The court said exactly that, Judge. Do we have control? Judge, I don't even know who this person is. I've never spoken to him. We don't have control over him. And we've told them.
Well, let me ask you this then. Have you spoken to Mr. Vargas, and is this gentleman either related to or under his employment as this litigation goes?
Judge, if I may have 1 second to consult with my associate who's right here to ask him that question.
Yes, I need to know.
I
that.
don't personally know.
I need to know that.
I remember that hearing.
and I know this, I know the answer to this.
The answer that was given was Mr. Vargas had contact with him, called him, and he said he was not willing to present himself beyond being subpoenaed.
Here's the point, Your Honor. He was subpoenaed. And
So then we need to follow up on that subpoena. If he refused it and he disobeyed it, he's disobeying an order of the court. We can have him attached.
he was subpoenaed. Because Mr. Hinojosa asked that the deposition be postponed, I said, okay, I'm gonna be easy, but you're gonna get in charge of this guy. Same type of situation that we had with Magana. This is, Your Honor, kind of playing games here. This is his brother-in-law, okay? The sister, his sister is part owner of Mexum. Mexum that's a party to this lawsuit. So this is not somebody that you really don't have control. He can ask the gentleman to sit for a deposition.
Well,
Respectfully, Judge, I've got two.
but that's not what you're asking, Mr. Rodriguez. The representation, he called him and he said, you subpoenaed him.
He did. He was subpoenaed. I'm telling you.
And he didn't show up. So what is a remedy, in your opinion, when somebody is properly and lawfully and timely subpoenaed and is not show up at the place where he's been subpoenaed for testimony? What is a remedy?
Writ of attachment.
I think you could put him in jail, Judge. I think.
Well, why don't we try our remedy? Why don't we try that? That if you have an address, I will get him picked up and brought into court in shackles, and you can depose him in here.
If that's what the court wants to do.
Well, no, I want to avail myself of the remedies that I have to enforce a subpoena that has been disobeyed.
And I think one of the remedies that you do have, Judge, because what Mr. Canales doesn't tell you is, I asked Mr. Vargas about this, and I said, can't you just ask him to do that? I've got him on the phone, and he says something to the effect of, well, if the judge tells me to, then we'll do that. And so I'm just asking, Judge, can you ask Mr. Canales?
Mr. Canales, ask your client to call his brother-in-law to submit, because I do not cherish the notion, and nor do I want to take that step of having him arrested by somebody, brought to my court under contempt orders, that I want him to cooperate. If he was previously subpoenaed, he got his subpoena, he was properly served. He needs to sit down for that testimony when you guys can agree to do that. But if he fails to do that, he will leave me no choice. You tell this to Mr. Vargas. Tell him that I do not want to pick up his brother-in-law like this. I'd rather not. But that's the remedy that I have under the law when somebody disobeys a subpoena and doesn't show up.
I wholeheartedly agree with you, Judge. Like I said, that call was made in front of my associate. The guy refused. We will make a second effort and report directly to the court by written motion to tell the court what happened.
And then you also tell Mr. Vargas that he previously agreed that if I ordered it, I have ordered it. He needs to impress that on his brother-in-law, that this is under an order that he said he would be willing to obey. I'm ordering him to contact his brother-in-law, advise him of the possible consequences if he doesn't obey this. I do not want to go there. I'd rather save him the embarrassment, but he will not be comfortable walking around this county or anywhere in the United States if he disobeys this subpoena.
I agree with the court, Judge, and the reality, he has disobeyed a subpoena, and the court has its remedies. I will represent to the court that we will make our best secondary efforts again.
Yeah. And if he come and tell me, no, you do what you have to do, well, then we will do it. And he will, I don't know what is going on. I don't know what his life's about, but it will be disrupted.
I don't either, Judge. And like I said, we don't have control over him, but we'll do our best to try to convince him and explain the court's position.
Okay. All right. The court, anything else, Mr. Rodriguez? Because I got to be going to a meeting, so I hate to cut you off. Can you remove your screenshot, please, for me? Unless you're going to need it anymore.
This is where the court needs to just, it's straightforward. It's 2 minutes. The court ordered Mr. Vargas, okay, to produce documents, Your Honor, and it was clear, okay. The court.
I'm just looking at the first page. Are you scrolling this thing, or because it's not moving here?
I'm sorry, Your Honor.
It's only the head, the first page, the heading of the hearing and all that, and the date. But I don't see anything else that you're referring to. Oh, there you go.
So the court. Let me see. Hold on here. On 69, the court says.
The other way. The other way. What's with the
Page
pink?
69.
Can I ask you something, Mr. Rodriguez, just on the side here?
Yes, sir.
What's with the pink color, the yellow color, the green color? What do they signify?
The green was me, Your Honor. The yellow is the witness, and you're in red, Your Honor.
Okay,
And the court made specific orders regarding the loan documents.
page,
Right here, Your Honor. It's page 89, page 90. You say
Okay.
your
your
lawyer,
lawyer has just clarified that they're not in the box. The loan documents, the original loan documents to both lenders that you originally borrowed, what you claim to be $3.8 million, $4 million initially. We want those documents, number one. Number two, if those loans have been extended, modified, current, we want those documents. Number three, we want the balance that they were at when you extended them with and currently. We just want to see where you're at financially. We want to know what's been paid, what hasn't been paid, what is the original amount, when was it extended, and for how much was it extended, for what length of time it was extended, the balance on those loans. Where do we get that information? Okay, got it.
we don't want to have any more problems. We want the actual documents. You have a question as to what I'm asking. You are on the record, sir. I'm giving you an opportunity to tell me right now that you do not understand or whatever, because I'm going to hold your feet to the fire. I want those documents. Do you understand what I want?
I know, I remember some of this because I remember, again, I remember that those were very tortured proceedings when Mr. Vargas was testifying. Very confusing.
And we didn't get one document since that time frame, Your Honor. And I want
It involves the loans that he claims where the money came from?
everything you told him, 1, 2, and 3, all of that information. We never got a document from this date, and it was clear. And I don't want to belabor this, but you said it again at the end of the hearing, and we never got any documents. And the court should find him in contempt of that. And I'm respectfully requesting.
I'm not gonna find him in contempt of that, but here's what I tell you, this court will seriously think about doing it if this doesn't get straightened out. He will not be able to provide a defense or any evidence that he contributed to the syndicate without those loan documents. He's testified already that that was the source of his money for the initial investment in this matter. I made it very simple for him, and pursuant to that language, I remember, I made it very, because it was again very confusing.
Hold on.
He would say something, and then second say he would say something else, so I was confused, so that's why I kind of took over the testimony. I remember that. And I was clear with him, and I made sure that he was clear about what I wanted and what we wanted, and what you wanted and what I wanted him to produce. If he has not done that, and they're not gonna do that. Okay, hold on, Wick.
Tony?
Okay,
Oh,
I can hear.
okay.
We can all hear now.
Yes, sir.
Well, it's got my court report's having difficulties with our computer. Something's going on. Stand by, gentlemen. We're trying to fix it.
Okay, Judge, I'm at Moy's computer. Can you tell him that?
Ring off at 10, guys, but I think it's me anyway.
I came over here, Judge. I came over here. I don't know what. Do you hear it? I don't know what's wrong with it. So I'm here. Yeah.
Okay. You guys have burned up one court reporter machine. So that will be added as court cost in this case. All right, don't burn the second one, Mr. Rodriguez. Yes, getting back to this point, I remember distinctly and calling and reading those words remind me what a confusing day that was. But I thought that after I had said what I said and it was really clear to him and I was speaking to him to make sure he understood. Mr. Canales, these documents need to be produced. He's testified in court they exist. He has claimed this as being the source of his investment in this enterprise that is the subject of this litigation. I can't find no better example of relevance than these documents. They're extremely relevant. They're questioning all this and they're entitled to have information. He told me he claimed he had them and he understood it. Why have they not been produced? Or is this something you're catching up with? You were unaware of this order?
So I was unaware of the order, Judge. If Mr. Rodriguez would have, before he filed the motion, let me know, we would have started working on this or try to figure out to get to the bottom of what is going on. That's primarily what I would tell the court. And if they exist and they're in his possession, we're going to get them to Mr. Rodriguez. This is the first I know of this order.
Right. Mr. Canales, I'm not going to fault you on any of these delays, okay? Because I know that Mr. Vargas has, like I said, provided some very confusing information even in open court. But let me, but let me suggest this. This is the court's intention because I don't know how else to handle the fact that he will not be able to produce these documents when he's testified under oath that they exist. Number
Judge,
one.
if I may address.
Number two, if in fact he doesn't produce them after saying they exist, then the only consequence I know is that he will have not a way to either prosecute or defend a claim that is based on these documents where these documents become relevant.
Judge, if I may address the court, I think the court and Mr. Rodriguez and I have had many conversations about this, and the court's alluding to it right now. My client is, since I've represented, I've become very well aware he has some cognitive problems, Judge, mental problems. He's actually on some very strong medication. It's almost like an Alzheimer's medication. He's had some health events that affect his ability to understand what he said a month ago to what he said now. And so that's playing out right here on the screen for Mr. Rodriguez. The court is actually alluding to it. He's confusing. He confuses me sometimes, Judge. And so I have had difficulties with his cognitive ability to assist me at times. It's like I've got good times and bad times. And so that's what I've dealt with.
Well, look. Again, recalling information that came out of those hearings. He is not the only one that has knowledge of this.
Correct.
So if Mr. Vargas is incapacitated due to mental defect, you need to do the appropriate thing.
And we're looking at it, Judge.
This lawsuit through a representative who has as much knowledge as he has of his documents.
And Mr. Rodriguez is aware. He's seen it, Judge, firsthand.
Because to a certain extent, Mr. Canales, the documents will speak for themselves.
Agreed.
So we need to see them in the alternative. If we cannot, Mr. Vargas has suffered some mental deficiency due to whatever, then the best evidence is going to be those documents which actually reflect or do not reflect what he said in prior sworn testimony.
Agreed.
All right. So have you seen any of these documents?
I have not personally seen any of these documents.
Has your assistant seen any of those documents?
No, Judge, we have not seen any of the stuff that is the subject of the motion to compel. I understand that now that the court ordered, because I've seen Mr. Rodriguez's motion to compel, and as an officer of the court, I will tell you, we will work on it immediately and bring him in and show him. If Mr. Rodriguez would be so kind as to share his version of the record so that I can outline what the court ordered for my client to produce so that I can start working towards resolving what the issue is right now.
Well, I'll take the liberty of responding for Mr. Rodriguez. He will be so kind to do that.
Thank you, Your Honor. I'll be glad to. I remind the court, this is not a motion to compel.
It's a motion for contempt.
Yes.
I got it. Yes,
This
sir.
was ordered by you back in September 9th of 2019. This should have been produced back then. This is not a motion to compel. So we need to stop referring to it as a motion to compel, Your Honor.
I'm not referring it to as a motion of contempt. I know it's a motion for contempt, but he
Okay.
hasn't done it yet, and he didn't comply. So you tell me back.
Okay.
Go back to your transcript. Tell me by what deadline did I give him?
Well, I don't recall. I believe you had asked Mr. Hinojosa, can you do this in 2 weeks? I don't recall. I don't want to
Right.
remember.
Well, if I ordered a specific date, you put through this record and you show me that I said you need to produce this by October 15th or something like that.
I could find that, Your Honor. I'll be glad to look for it.
I gotta get going. I have to give a speech. What? Okay.
Does it matter because you're giving him a chance to do it anyway? So are you telling him?
No, but look, but in order to have a viable motion for contempt, Mr. Rodriguez, I have to have that he violated by a specific date. So this is a discovery dispute now because if I didn't give him a specific date, it becomes a specific discovery dispute, a non-compliance with discovery instruments, and there's different consequences for that. Okay?
And I don't know, Judge, if there's an order either, but we're trying to get all certified copies of all
Yeah,
pleadings.
I don't remember issuing an order that way, but Mr. Rodriguez, I'm sure knows because he's more on top of this case than I am.
I want.
Is there an order, Mr. Rodriguez?
I do not believe there's an order. This is your order to
Yeah,
him.
it's an open court order, right?
Yeah.
So then I need to know if there was a date that I told him to comply by.
I can look, but before we go there, Your Honor, I want to make sure, because this is something I do recall and that you said, because at this hearing, Mr. Hinojosa was given a spreadsheet. Do you remember that? And you said, no spreadsheets. They want the document. So I want to make sure that we don't get a spreadsheet that he puts together. We need the documents. Do you recall that part of the discussion, Your Honor?
I'm reading it right now. If I didn't, now I do.
Okay. And so I want to make sure that Mr. Canales doesn't leave the conversation because Mr.
Yeah, I want the actual documents. Let's be clear.
If you recall, it was Mr. Paral, the guy we're talking about, that handed Mr. Hinojosa the document. So,
Right.
so
Well, we've taken care of that too. And if you know what, if after the discussion Mr. Canales has with Mr. Vargas to advise his friend or relative, whatever he is, that if he does not submit a deposition, I'm gonna have to have him arrested.
the point is what you were getting to, Your Honor, if he's incapable, put the guy that is capable of talking about it up. And I'm saying it looked like he is capable. That gentleman is one.
Okay.
Okay. Are we moving on or
Yeah, we're gonna move on. Here's what, let me summarize where we're at, where I think we're at. You are going to give a copy of this transcript to Mr. Canales so he can be painfully aware, or at least the relevant portions that show where I spoke and ordered Mr. Vargas to give you the documents, okay? Specifically. Can
want
we?
the colored copy?
Okay. Yeah, provide them to Mr. Canales so he can sit down with Mr. Vargas, say, here's what the court said, and this is what you told me you understood, and this is what you told them you would do. Now they want those documents, and you given them to me and not given them to me. That's where we're gonna go with that. We're going to, your motion for contempt is going to be held up, subject to you showing me that there was a specific date that I ordered him to comply with. You maintain that the record reflects that Mr. Hinojosa represented, or that I ordered Mr. Hinojosa within 2 weeks, and Mr. Hinojosa approved that. You show me that section. Finally, I'm going to order Mr. Vargas not to provide us a what do you call it?
Spreadsheet?
A spreadsheet summary of the documents. We do not, that is not what is being requested, and that's not what the court ordered. Mr. Vargas, when he did not appear to have significant mental impairment at the time he testified a couple of years ago, so it was made to understand clearly what this court was ordering. And I think that the court ordered documents that were consistent with what he was testifying about. The frustration was that the numbers were moving after every other question. So that's why it became absolutely necessary that instead of trying to figure out where was he standing, we wanted to see, and Mr. Rodriguez was entitled to see the actual documents because of the way Mr. Vargas was testifying. So no spreadsheets, the documents. I'm going to give Mr. Canales, once you do that, an opportunity to do that. Mr. Canales, you're going to carry the water with me through Mr. Vargas to this gentleman.
Yes,
To
sir.
get the word to him that I do not want to exercise that ordinary power that I have to get him arrested, but I will because I want this lawsuit to proceed in an orderly fashion with documents produced. And if he does it, then he does it at his own peril. Okay?
Judge, the only thing that was left out, I know you're busy and you got to go, is that we're going to submit the recommendations for discovery master.
Yes. Mr. Rodriguez, you sure you don't want to offer me any suggestions?
Sure, I will.
Okay, I'll give you till tomorrow. Send me something through my office, and then I'll take a look at them, and I'll appoint a master immediately. Okay.
Thank you, Judge.
Thank you. Thank you both.
We had other motions, but I take it you want me to draw those down for now?
Would you please?
Your Honor, what I would tell you, what I would tell the court is we have a pending MSJ.
I have seen, and I don't want to rule on that because Mr. Canales is going to say, well, Judge, I just got this 10,000 documents and may be responsive, may help me respond to the summary judgment. But I am going to set it for a ruling in about 45 days. And that should give Mr. Canales sufficient time to go through all the documents that he has, whatever, if he hasn't been responsive, to amend his response to the summary judgment. And I'm going to rule on it. Okay?
We have a motion to strike regarding his affidavit that's attached to his response. I'd be willing to argue that it's a good one, but it's part of the.
Well, let me ask you this. Given the amount of time that I'm giving Mr. Canales, is that defect curable?
No, because in two sentences, his affidavit that he's attaches to support his response is the same thing that the court has already dealt with. It's a bunch of lies. and it's provable lies. And so that's how I would respond. It's not curable.
So you're telling me that the affidavit is not trustworthy?
It's totally untrustworthy. Just
Okay.
like it was very similar to the testimony that you got from him and couldn't get him straight on. It's exactly like that.
All right, well, I'll take a look at that motion to strike. Ms. Solis, can you tell Ms. Salas or Ms. Ramirez that give me that copy of the motion to strike the affidavit of, who is the affidavit of who, Mr. Rodriguez?
Hector Vargas.
The affidavit of Hector Vargas. When did he execute that affidavit?
While I represented him, Judge.
Well, how long ago was that affidavit submitted?
Last year, the fall of last year.
And are you representing to the court since that time you yourself have personally witnessed a dilapidation of his mental condition?
Absolutely, Judge. I've actually talked discussions with Mr. Rodriguez, candid discussions to tell him that I'm not sure that my client is mentally fit to even be a witness anymore.
Did you believe he was mentally competent at the time he executed this affidavit?
I believed it then, but I don't know that I believe it in retrospect, looking back at his behavior from the depositions to the meetings that I've had with him. I don't know that since the moment that I met him that he's actually been mentally competent.
Mr. Canales, I don't want you to feel insulted by this, but I'd like you to put your hands on this file more instead of your assistant. You need to be making sure, because I'm gonna ask you to make representations to me. And I do not want to say, well, I was with my assistant that, no, I don't want to hear that, okay? Here's what we do. I will take a look at that affidavit as soon as I have it, have my hand on it. I will look at it. But if it does reflect part of the problem we've been discussing with Mr. Vargas has been and the court can't help but make a comment on that, because all this has revived my memory of that day when he testified, and it was very difficult to follow him. Very difficult. I mean, I was like, what the? So that's when I finally got a little frustrated. I guess you would call that. Right, Mr. Rodriguez?
Yes,
You remember that? Yeah, that's when I got a little frustrated, and I let the worst of me take over. But I was very frustrated at his testimony. I mean, one moment he would say that, and then all of a sudden, what? You just backed off of what you said. Well, what's the truth here? I mean, so I was having a problem with him. I don't know if the problem comes because what, but you know, this has been going, and I would think that a businessman as him or whoever's around his circle that, hey, well, here's the damn documents. Here's where all our money came from. Here's your balances. What else do you? I mean, you know, because here it undercuts the whole interest that he had. I believe he has an interest. I mean, I don't have any reason not to doubt that there's some interest there, but to what extent and from where is the issue? So please prevail on him as best as you can to communicate that I do not want to go to extremes on this, but I am fixing to, because we need to get this information done, because I want to have cake for my birthday in the form of a trial. All right.
Thank you, Judge.
Thank you both. Ms. Solis, make sure Ms. Salas knows that I need the motion to strike the affidavit and the motion for summary judgment, okay?
With the exhibits, Your Honor.
With the exhibits, okay. Thank you, guys.
Thank you, Judge.